Good afternoon, ladies and gentlemen. Welcome to the AIA Contract Documents webinar, the Owner-Contractor Agreements and Sustainable Design and Construction. This webinar is regarding the AIA 2017 release of documents. My name is Hasti Hijazi. I'm Director of Global Innovation Education at the AIA, and I will be coordinating today's webinar. Just a few administrative items before we get started. You will be sent the PowerPoint along with the recording of today's webinar at the conclusion of the program. You'll also find the PowerPoint as a handout in your GoToWebinar window on the right-hand side. I have all attendees currently muted. If you do have any questions, please enter them in the question or chat in your GoToWebinar on the right-hand side. And at the end of the program, time permitting, we will try to answer as many questions as possible, again, with time permitting. This presentation is protected by U.S. and international copyright laws. And this program is eligible for one AIA HSW learning unit. When you registered for the course, you entered your AIA member number if applicable. Once this course concludes, I'm going to collect all of those AIA member numbers and report the credit directly to the AIA. Your credit will appear on your online transcript within the next 7 business days. You can also email me after today's program if you'd like to request a certificate of attendance. So now I'm going to be introducing our speakers before turning it over. Our speakers for today are Forrest Lott, FAIA, Principal of Lott & Barber in Savannah, Georgia, and Kevin Miller, AIA, Principal of GSBS Architects in Salt Lake City. Both Forrest and Kevin have been working together on the AIA Contract Documents Committee for the last 10 years, and they have both chaired that committee as well. So we're very lucky to have them today. I want to thank you both for taking the time to not only present today, but for creating the presentation. And now I will go ahead and turn it over to Forrest.
Or Kevin.
Or Kevin.
Good afternoon, everybody. Let's start with the course learning objectives. I'm not going to read these slides. For those of you that are here to get CEUs, you've seen this before and you know why they're here. There's a second course learning objective. What I will touch briefly on are a list of things we hope that Forrest and I hope you get out of this presentation. We want to talk to you a little bit fundamentally about how we go about drafting the AIA contract documents, how to choose, how the choice of the owner-architect agreement affects the relationship of the participants. Hopefully you're going to come out of this with an ability to advise your clients a little bit better on which form of agreement to use. Of course, what we've changed in the 2017 revision to our core documents, and then the exhibits that we've created that are new here in 2017 that bolt on to these agreements. And at the end, we'll tell you where to go if you need additional help.
All right, thank you, Kevin. Let's take a quick look at the history of the program and the goals of the documents program and how we go about creating the documents. The primary goal is to establish and maintain standardized legal forms to enhance stability and the order of design and construction legal transactions to help us do what it is we do. They're designed to have a nationwide application so that they're subject to a uniform legal interpretation. The image on the right of this slide is from the cover of the uniform contract. If you want to look at the entire historic document, it's available on the AIA documents website. It's interesting. I noticed that at the bottom of this near original agreement, it says that suggestions for improvement should be made to the Standing Committee on Contracts and Specifications at the Octagon, Washington, D.C. Committee name has changed a little bit, and we've moved into a little bit nicer digs behind the old Octagon building, but that same commitment to improving the program remains. And the program has grown over the years, reflecting the complexity of what we do in the construction industry. We've got a lot more documents and a lot more participants in the drafting and revision process as well. So the guiding principles are listed on these, and this slide we sort of touch back in our process to make sure we are doing these things. What makes the AIA documents industry standard, besides they are used a lot throughout the country, is the volume of legal case history and the precedents that have grown up around the language and the concepts that are in the documents. With each new release, the design, construction, and legal professions, as they're doing right now, and as we're doing, are quick to compare, evaluate, and educate the industry regarding any of the changes. The simple fact that they've been around as long as they have is a testament to sort of balanced nature. Any standard form agreement that favored one party to the detriment of another would fall out of favor in short order. Much of the contractual language is really about the allocation of risk to a party that's best able to manage and control that risk. Owners select sites, so they should bear the primary risk that results from that decision. An architect controls the design and selection of materials in response to a budget, so they're in a good position to manage that risk. All of that can vary depending on which delivery model you're using. All right, the drafting process. This is 2017. The last time we released these flagship documents was 10 years ago. It takes 10 years to get the documents out into the marketplace, to have them used, to have legal decisions resulting from the use of those documents, and go through the process. So we begin by looking at how the documents have fared since their release. We seek industry comments. We do market research. We talk to folks in the industry. We identify and engage what we call liaisons, subject matter experts that know about the content of the particular document we're looking at. We reach out to other AIA organizations, knowledge communities, that sort of thing. And then we go through this series of steps you see on 1 through 6. So we get to the end, we finalize and publish, and that publication still includes paper for now. We also offer electronic variants of this as a single basic document with limiting fill point kind of capabilities, a single-use document that you have great editing capability in, and then an annual subscription where you can look at everything the documents library has to offer. So a little bit about the committee. The committee began in 1887, 130 years ago, and the gentleman on the right, Grosvenor Attenbury, was the first chairman, and since that time we've had a lot of people serve in that position before Kevin and I had the opportunity to do so. The AIA has always relied on a committee of expert architects to help draft and update these documents. From the 3-person committee in 1887, it's grown to today's size of 35 design and construction leaders. The committee has always played an integral role in the creation of these documents. And we're looking at some of the products of this same continual process that's been ongoing since World War II. So Grosvenor was yesterday's committee, and here's a picture of today's committee. It's a good-sized group of very hardworking folks. They come from fields in design, construction, law, insurance. These committee members are from geographically diverse locations. They're from different size firms. As we talked about, the revision cycle for these documents is 10 years. And so we ask these people for a voluntary commitment that matches that 10 years so that we have a good chance for the institutional memory to be passed from one cycle to the next. A couple of folks on our image up here on the left-hand column, the lady with the white background behind her picture, Sue McClymans. She's a New York spec writer and additionally volunteers as an NCARB member. The guy on the bottom right is Chris Lasky. He is with a development company in Pittsburgh, a big Steelers fan, as you might suspect, but he represents the owner's viewpoint in a lot of our discussions. So you can see that it's a diverse group of committee members. You can go to the website and find out who is actually on there and who might be a member near your area. All right, so what's happening recently in the document program? What are the trends? Well, certainly more delivery models with construction management, design build, in addition to traditional design bid build. We've got several different variants on construction management. There's also integrated project delivery. We have specialty agreements for federal projects, for interiors, for task order deliveries where you might be doing multiple small projects for a single client. Also, there's some newer concepts that we'll be talking more about later in the program where we're using a modular approach to documents where we have an exhibit that gets attached to the principal agreement. We're doing that now for digital insurance requirements and sustainability. So the work of the committee has really expanded to include a lot of not only agreements, but educational and supporting information. We publish guides, comparatives. We put on educational content pretty much like we're doing now. So it's I guess in summary, a broad program with a wide variety of documents fully supported by all of this wealth of resources.
Okay, let's talk about owner-contractor agreements. Forrest showed you an image of that 1911 original owner-contractor agreement, the predecessor to A101. What's interesting, if you have the time to poke into that thing and read it, is there are a number of similarities in that document that still exist, more than 100 years later. Enumeration of the contract documents, payment process, liquidated damages are listed in that agreement. But of course, things change and we have to account for progress. And so as we'll discuss today, we now have a brand new insurance exhibit because it's such a complicated subject to deal with. You need to figure out how you're going to do the digital practice side of things, sharing of a BIM model with the contractor, and of course, sustainable design considerations all complicate the agreement from what it was more than 100 years ago. When it comes, go ahead. When it comes to, I'm sorry, Hosty, go to the next slide, please. There we go. When it comes to owner-contractor agreements, they fall into kind of two buckets. The traditional models, three-legged stool, traditional relationship of the parties. The architect works for the owner, the contractor works for the owner. There's privity of contract between each of the parties, but nothing all the way around. And the primary difference in those traditional models is how the work is priced and paid for. Is it some kind of a bid where the cost is certain, or is it a cost of the work model where you might have a GMP or simply a control estimate? And we just open up our checkbook basically to the contractor and say, we'll pay whatever it costs to build this building. The process under those models is a very linear one. You do design, either all of it or most of it or a chunk of it. You hand it to the contractor who gives you pricing, and then you go build it. Then the newfangled models, construction management, design build, integrated project delivery, all are predicated on the notion of earlier involvement of construction professionals. They represent a change in the traditional contractual relationships, who the architect works for example, in most design build models that get done today, the architect's working for the contractor, which creates sort of an unusual a relationship problem. Owners expect the architect to represent them, but if you're working for the contractor, your commitments are differently placed. Or in a P3, the architect may be several steps removed from the user entities. There are some other variations on the theme. Examples are program management, teaming agreements. But what we're going to talk about today in terms of owner-contractor agreements, we're talking about those traditional models. So in summation, then, what are the differences? What fundamentally, when the contractor comes on board, when and how the cost is identified, who is responsible to do what in each of these arrangements, the degrees of collaboration. In theory, a construction management arrangement leads to a higher degree of collaboration between designers and constructors. And the owner's checks and balances, the ability to figure out what's going on financially, in terms of schedule and in terms of the quality and of the design itself. Why do we have all of these models? Well, because the priorities vary amongst projects. Sometimes the most important thing to an owner is to get the lowest cost project, and typically a design bid build model has resulted in that lowest cost project, at least at bid day. We all know what that looks like down the road. It also can have to do with how much information you have available at the time that you bring a contractor on board. There are models, and we'll talk about some of them today, that allow the design to progress after a price has been given versus having everything all figured out before you go to the market with it. And of course, risks, and that's probably the most important one. Who is bearing the risk of the construction cost of the project, and do we want the contractor to bear it after we have executed a contractor, or is the owner willing to accept some of that risk in return for benefiting if the project costs less? So how do you decide which one to use? Really, there's no perfect model. Each project needs to match its delivery model to the specific aspects of the project, the locale, the participant experience, and the project objectives. You also have to figure out the points of responsibility, design and construction. Who's going to oversee what's going on? For example, a design build owner has a single point of responsibility. A lot of owners like that a lot. In the CMA, the owner looks to the architect and his CM, and the CMA has some overlapping responsibilities for both the architect and the constructor's participation in the project. Then there's the degrees of collaboration. At the one end, design, bid, build, which has virtually no collaboration between the constructors and the architects. And at the other end, IPD, where everybody's in the pool together trying to figure out how to get the most bang for the owner's buck. Regardless of the form of contract or delivery model that we land on, at the end of the day, you have to have all of the parts that go into making a contract together in order to get there. So you often say, hey, well, where's the contract? And we pull out an AIA A101 agreement form, but that's only a piece of this picture. The agreement has just the basic information captured in it, the parties, how the exchange of money for the project will occur, the administrative process. There's nothing in the agreement that tells you what you are buying. That information is in the drawings and specifications. And then included in those drawings and specification are the general conditions. The cost requirements and supporting systems are typically not incorporated in the completed work. The rules for how we, the project participants, will behave through the project. And when it's all over, the drawings and specs are still pretty valuable as an operating manual for the building. But if there's no dispute or other reason to go back to that original agreement, the agreement and the conditions have ceased to really have any value to us. A101, 102, and 103 rely on the content of an A201. You can't have a complete agreement without having both of those pieces, as well as the drawings and specs and the other things I've been talking about. If you want to know more about A201, I think there was a course a week or two ago on that, and it's been uploaded, and you can listen to it on our website. Be cautious about modifying A201, though, or more specifically, having your owner's attorney modifying it. The documents within the A201 family, which includes A101, 102, 103, as well as B101, 102, and 103, are fully coordinated. And so the responsibilities of the architect outlined in B101 are coordinated with the responsibilities in A201 that the contractor expects the architect to perform. If you modify all that, you run the risk of creating gaps or duplicating expectations inappropriately. There is a source of information that can help you with this called the Uniform Location of Subject Matter. I think it's listed in at the end of this presentation. It tells you where a group of people have decided the appropriate place to call out or to put all of this information so that you don't run that risk of duplication. And then lastly, I would caution you that know what's in the agreement and know what's in A201. Division 1 specification sections should expand on that information, and too often I see people duplicate information in their Division 1 that's already covered in A201, or even worse, they'll contradict what's in A201.
All right, so let's take a moment and look at what's in the 2017 release of these three owner-contractor agreements Kevin was talking about. For the most part, all across the board, the changes don't affect the fundamental arrangement of how the parties work with each other. As the slide says, they're evolutionary, not revolutionary. But we looked at what was giving people some challenges and perhaps misunderstandings as they were using the previous 2007 version. And we saw that we had some opportunities to minimize the parties' ambiguity in their expectations. And one of the ways we can do that is if you fail to use one of the field points we've offered where it's appropriate, we've provided a default. And because we have this ability to edit the A201, that happens differently than it used to a generation or so ago, where a printed copy of the general conditions would be bound in the specifications and you would modify that through some additional document. Now the direct editing of the general conditions is possible, and that creates the possibility that you could get an inappropriate cross-reference to some of the section numbers. So we've simplified the referencing to the general conditions within the agreement, in essence, to get you to the right neighborhood, but not tell you exactly which clause is referring to there. So there's a trade-off between the ease of immediately going to the exact reference and then having to do a little bit of looking in that area to find the cross-referenced general conditions article. But when we discussed it at the documents committee level, we thought maybe that'll prompt a little more reading of the A201, and that's probably a good idea. All right, so let's talk about what has changed. And this applies to all three of the documents again. We'll talk about the contract sum, the contract time, and then how the payment is calculated. First, to the contract time. This is the text out of the 2017 documents. It's the same in all three. At the bottom, you see the little highlighted area, and that's where we put the default in. So if you can't figure out which box to check, you inadvertently miss it, there's still an answer for this, and that would be the date of the agreement. But we've provided these other options. Often there's a notice to proceed issued, which is the second box. And then we have this established as follows, sort of an other. And in that case, we'd expect you to add whatever information is appropriate to the particular project circumstances. It might be a certain number, like 10 days after the issuance of the permit. So anyway, that's an example of our default position for data commencement. So at the end of the process, when we're looking to conclude the project and we're trying to determine substantial completion, that's a very important milestone in the life of the project, we provided some additional clarity here. The old way simply listed a number of days, and then you'd calculate that from the date of the agreement and track total project duration that way. And then we had an other blank, and sometimes people would indicate something else, but a careful read of the form was a bit confusing. We also suggested you might talk about partial substantial completion in the same sentence. We recognize that a phased project, portions that get completed at different times, is a pretty normal occurrence. So we've added in the bottom Article 332 there a way to indicate a portion of the work and then a separate substantial completion date for that portion, recognizing that the date above is for the entire project. So you might have an office building that's completed before you demolish an existing building and then convert that space into a parking lot, or you may be phasing the work, such as a number of housing units where you're doing 25 at a time. So you can indicate that phased substantial completion here, but you should give consideration to when such things as warranty periods begin, transfer of utility obligations for these phases. So when you're getting to the end of some work, there's a change in expectations that happens between the parties. So it can create a little more complexity that you need to make sure you coordinate it with the rest of the documents. And then selfishly, from an architect's viewpoint, if you establish multiple portions of the work, you might want to examine whether or not there are additional services you're entitled to for closing out all of these multiple mini projects. Liquidated damages, as Kevin said, they've been around since the beginning of the documents program. Their use varies widely depending on the project scope, the area of the country, the method of delivery, etc. But we recognize that the language that was previous was pretty limited. If you look at the top italicized text, it says, well, insert provisions, if any, for liquidated damages. We kind of felt that might be a little bit too hidden within the text of the document. So it has its own article. There's an opportunity to identify those liquidated damages that are essentially an amount that the parties agree to that quantifies and liquidates the owner's damages resulting from a failure to complete on time. So by that, the owner waives claim for other damages, and it's an opportunity to maybe avoid debate or dispute about what those damages are if you define them up front. It's important to remember that liquidated damages are not punitive. They are supposed to be linked to the amount of real damages that should be demonstrable by the owner. And you shouldn't really think of them as a big stick. There shouldn't be some ridiculous amount in there that you think you're using to force the contractor's adherence to the schedule. Sometimes it may not be a good idea to include them in the project at all because the contractor may price that risk in. But the concept of having these liquidated damages lets a contractor manage the risk of completion on time and understand that, allocate that risk downstream if he wants to. Give consideration to the owner's true strategic objectives, because if getting the project early does not benefit the owner because he's got to pay utilities to take care of it or whatever, and it doesn't benefit him, then liquidated damages may be detrimental to the project rather than a benefit. So the other side of that coin are incentives. We provide a 4.6 as a sort of a fill point just to record anything that you might want to include for bonus or other incentives that might change the contract some because project objective is achieved. And that doesn't necessarily even have to be related to time, but it should be related to the beneficial objectives for the project. So if you're using either or both of these tools, really give some consideration that including them in the contract places more attention on contract time, what is an acceptable justification for extending that project time, what are those causes for delay. All of that can place additional burdens on the parties to manage that time in a different manner or more stringently than you might if liquidated damages or incentives weren't a part of that. So pay attention and give careful thought to the true objectives with these items. One of the other changes that we made across the board was trying to give clarity to ways that the project is anticipated to be modified at the outset, and that's alternates, allowances, and unit prices. The example on the screen looks at a base bid condition that might be concrete block, CMU, and then how you might use other masonry products in there. And in looking at it, we recognize that alternates generally come in a couple different ways. Initially, they're an offer by the contractor, and the owner can make an election to accept or reject that alternate. If accepted, it's included in the contract, of course. The new language differentiates between the first line, which is alternates that are accepted at the time the contract is entered into, and the second line, which may be for exactly the same kind of material as in this kind of example, is for those alternates that are accepted either at a later date, certainly after the execution of the agreement, but subject to certain conditions. So there's a place to describe the item, the price, and those conditions for acceptance. You might be able to accept it up to 60 days after notice to proceed or some other issue. Allowances, however, they're a lump sum assigned to a specific portion of the work, such as blasting rock, driving piles, or procuring light fixtures, that where we often are missing or don't have locked down some information, maybe quantity or quality or whatever. So we include a cost in there that is for that item. Once the allowance is converted to a known cost, you'd adjust that by a change order. Initial allowance is part of the contract sum. If you spend less or more, then you just adjust. Unit prices facilitates calculation of changes in the contract sum by limiting the variables to really only determining the differing quantity of an item. The description of the item and its unit cost is established by agreement, and then you just do the calculation and execute the change order. The rules for all of this, Kevin made reference to the general conditions in Division 1. Division 1 typically talks about how you administer these processes. The agreement is really just the place to record the agreement on that. In this example, there are a couple of different unit costs for varying quantities, recognizing that it may not be the same price to buy a little of something as it is to buy a lot of something. And then one quick reference to the general conditions. There's language in there that essentially says that if the unit price results in an unfair allocation of the pricing because the quantities are either way more or way less than could be anticipated, and it creates an unfair advantage, then the parties should renegotiate that particular issue.
Another item that changed fairly significantly in the new version is how the math is done for the payment amount. It's not so much that we changed the underlying theory so much as the language was really confusing, and I'll just give you an example of that. So it used to read, subject to other provisions of the contract documents, the amount of each progress payment shall be computed as follows. 1, take that portion of the contract sum properly allocable to completed work as determined by multiplying the percentage completion of each portion of the work by the share of the contract sum allocated to that portion of the work in the schedule of values less retainage. 2, add that portion of the contract sum properly allocable to materials and equipment delivered and suitably stored and it goes on. Then there's a subtract and a subtract, and then there's a further modification. We thought it made a heck of a lot more sense if you simply said, look, these are the things that are included, then you subtract these things, and you get the certified amount. As a side note, it's important to recognize that the schedule of values that underlies this payment amount conversation is not an instrument of an audit trail. Instead, it's really an agreed upon metric to determine the value of that completed work. And the distinction is maybe a little bit subtle, but you shouldn't expect, for example, that the concrete subcontract amount is exactly the concrete line item in the schedule of values. Why? Well, because we need a tool that allows us to streamline the payment process, not so much provide a detailed and full accounting of everything that's going on, that doesn't rely on those on us reviewing itemized costs and contracts for every component of the project. We also clarified retainage. The old version of the contract buried retainage, its amount and conditions in the formula for calculating a progress payment. So it wasn't even explicitly described in the contract. It simply was accounted for in all of that silly math that I described a second ago. It wasn't particularly clear, and it didn't really encourage the parties to discuss the terms under which retainage would occur. The new way created this new Article 517 that describes all the conditions of retainage, and there are two fundamentally: retainage prior to substantial completions, which allows us to talk about items that are not subject to retainage. As an example, you might not retain on general conditions, and that in and of itself is a new concept introduced in the 2017 documents. It also spells out the rules for reduction. Work is on schedule, 50% complete, and also providing some consideration for early out subs. Just don't forget that you have to get the consent of surety in order to let anybody off the hook when it comes to retainage. And then the rules upon substantial completion, which typically there are none unless you put something in. A common misconception is that retainage is held in some portion until final completion. That's not what we hold. At substantial completion, we release retainage, and a separate sum is identified that represents the value of the incomplete work. You have to remember that retainage is largely the subcontractor's money and is intended to ensure that there are sufficient funds to complete the work if the contractor fails to do the work, not the subcontractor. I want to talk a little bit about termination. All three agreements have a provision for termination for convenience, which is a relatively novel concept in the contracting world, actually, not all that novel for construction. Most times contracts anticipate that the parties are obligated to do whatever the contract requires, and that's the end of that. But the AIA 101, 102, and everybody else give the owner an extraordinary benefit, and that is the right to terminate without cause. For example, their funding falls through, maybe the business condition changes and they don't need that building anymore, or they think they can get a better deal somewhere else. In return for that benefit, previous versions of A101 used to say that the contractor was entitled to lost overhead and profit, as well as the direct costs of closing out the contract, i.e. getting rid of all the subcontractors, terminating their agreements, all those things. What we learned as a part of the process that Forrest outlined at the very beginning is that owners routinely struck that overhead and profit language, and because the owner was in the catbird seat, the contractors rolled over. And we didn't think that was particularly fair. So the new approach is to identify an agreed-to fee for such termination that allows the owner mostly to quantify its risk of terminating for convenience. We think that fee can be structured in a variety of ways. You could do a percentage of the remaining work, a lump sum, or a graduated scale, just appropriate to how you think about it, what the parties want to agree on. But the point is that this should be a point of negotiation. There is an issue that we should highlight here, and that is that that the subcontractors are not necessarily included in this agreement. This only liquidates the general contractor unless they fill in the other options. And so typically what happens is a contractor's termination cost for termination for convenience can be identified here, but you will still have the costs of terminating the subcontracts, and generally this language doesn't get passed down. So we have two fill points. One is the standard provision, which only covers the GC, and the alternative includes the termination costs of subcontractors, which can be substantial. All of those things are across the board in 101, 102, and 103. So now let's talk about the things that are unique to the other two agreements. In A101, the contract documents are, as I think we all know, simply priced, yielding a stipulated sum. 102, which is the GMP version of the agreement, allows that the contract documents may require further development, and it introduces a concept of contractors' assumptions to budget for that development. So what you see in the documents plus the assumptions for further development lead to a GMP. And the GMP is the maximum amount an owner is obligated to pay for the cost of the work and the contractor's fee. The A103, as I said early on in the presentation, is where you hand the contractor your checkbook. There is no guaranteed price. It simply utilizes those same contractor's assumptions to arrive at an estimate that informs the owner of the expected project costs, but by no means is that the limit of what you might pay. You just pay for what we build. In the A102 universe, you have a GMP, and we added two articles in A102 to clear up some common confusion regarding how GMPs work. First, in 12.1.5.1, that's a mouthful, it makes clear that the GMP is a whole, not the sum of its parts. That is, the contractor agrees to construct the entire project for the total GMP, but he's not agreeing that each line item of the GMP will be met individually. So it's not that concrete's going to be this much and brick is going to be that much. It's that the entire project will not exceed this GMP, and if I go over on concrete but I go under on brick, I'm still good as the contractor. Another common point of confusion in a GMP environment is how the contractor's contingency is allocated in the schedule of values. So we added language in the 12.1.5.2, and that requires the contractor to inform the architect that contingency funds have been reallocated to another line item. That requirement actually helps those of us listening who are architects fulfill our obligation to keep the owner informed on the general progress of the work and the review of the pay applications. And secondarily, as we all know, a declining contingency is a pretty good indicator of the contractor's likelihood of meeting or exceeding the GMP. And we all know what happens when we get close to exceeding a GMP in those situations. It starts to go a lot of directions for everybody.
All right, Kevin, thank you. The GMP is unique to the A102, and some of the differences in the 103, where you hand the contractor the owner's checkbook, exist in how information related to the project cost is developed and managed. So there is the control estimate, and that's unique to the A103, and it is a tool for monitoring the actual cost and the timely performance of the work, so cost and schedule. And the control estimate takes into account the cost of the work, the contractor's fee, the documents just like all of the models have, and then the assumptions, which the GMP variant also has. And all of that goes together to help the contractor develop his opinion of the likely or probable cost of the work, but not guaranteed. Once that control estimate is established, the contractor is required by the agreement to develop a cost control system. And that cost control system has to be updated every month as the project progresses. And sort of like the declining contingency, what happens over the life of the project is it turns from a lot of estimate to less estimate and more recording of the actual costs as the design nears completion. And so also common to both the 102 GMP version and the 103 with the control estimate is the owner's right to audit the final accounting to see if his trust in this system was well placed. So let's talk about that assumptions. This is common, as it says at the top, to both the 102 and the 103. Because it is likely that the contractor is developing either their GMP or their control estimate off of incomplete work, there's this yin that there is an if the contractor gets to include his assumptions, he also has to anticipate and include the costs for the further development, which would be presumably refinements to drawings and specifications. It doesn't require the contractor to guess what the designer has intended. The documents include a definition and a limitation that he should anticipate what is reasonably inferable from the contract documents. You know, if he's completely changing the scope or quantity of major systems, that wouldn't be reasonably inferable. An example would be if the drawings indicate a powered overhead door, but there's no electrical information indicated at this level of development in the drawings, it is reasonable to infer that some power sufficient to run an overhead door would be there, and the GMP should include sufficient funds for that. On the other hand, if the same drawing note indicated it was an overhead door but didn't indicate it to be powered, it's not reasonably inferable that since an unpowered overhead door is just as likely that the electrical portion would be included. So these assumptions are sort of the least defined element of the GMP or control estimate, and they're the most likely to generate debate and possible conflict. So it's important to be as clear as you can in the documents on which these cost control measures are based, and be clear on the outcome of the building. You don't necessarily have to detail it, but if you can indicate notation or reference to some standard or product basis, then you are helping the clarity of the project. And then also making sure that the owner understands the risk that results from this contractor assumptions, from the level of incompletion in the documents, and they plan to manage that risk properly through the use of a contingency. To mitigate the risk, the owner is obligated to provide revised documents. When the owner makes these assumptions, the contractor's assumptions are reviewed and accepted by everybody, then the drawings should be revised to reflect those agreed upon assumptions so that you have a better set of documents, and presumably the costing and schedule will be improved as well. And those revisions could take the form of reissued or conformed documents, change orders, or other modifications. And depending on the form of the agreement that the owner has with his architect, again, it's sort of a trigger that there may be additional services required. B101 lists conformed construction documents as an additional service under that Article 4 there. Article 3 is something we thought we should highlight. It didn't change in this version of the documents, but it's pretty important. It talks about the relationship of the parties, and the relationship under a traditional design bid build is you build what I told you and I'll pay you. Here it's a little bit different. There's cost uncertainty. In the 101, we know what we're doing. In the 102, the owner has cost certainty, at least on the upside, with the guaranteed maximum price, and the owner accepts the reward if it costs less. The contractor accepts the risk if the project costs more than the GMP. In a 103, the owner foregoes any cost certainty and pays the actual cost, presumably in exchange for some efficiencies or level of confidence. So the relationship of the parties, Article 3, talks about that trust and confidence that the agreement assumes. It expects the contractor to operate in a manner that furthers the interests of the owner, and expects them to perform the work in an expeditious and economical manner, consistent with the owner's interests. So even though the checkbook might be there or you're operating under the GMP, there is still a contractual requirement to operate in the interest of the owner as appropriate there. Subcontractors. This is a text-heavy screen, and we won't get into detail on it, but under the A102 and 103, the owner has a limited view sort of behind the curtain into some of these relationships that they wouldn't under a design bid build. 10.1 gives the owner the right to reject subcontractors for which they may have some reason to object. The language in the article was revised to make it clear that the owner is not responsible for selecting the contractor and which subcontractors' bids will be accepted from, but rather the contractor determines who gets to bid his work, and the owner, in consultation with the architect, may reject a subcontractor proposed by the contractor. If they do, the contractor is entitled to make appropriate adjustments to GMP or cost or schedule that results from using a contractor other than the one proposed by the contractor. And the owner and his advising architect should be careful when doing this so as they would not wish to inherit responsibility for the chosen contractor's failure to perform. Also, if the contractor wants to award a subcontract on a cost plus a fee basis rather than a stipulated sum, which is normal under both of these models, then the owner's authorization is really required to do that. Again, it preserves the owner's rights. The owner has the same right to audit that subcontractor who's on a cost plus basis as he would the general contractor. We'll talk about audits later.
So both A102 and 103 are cost of the work agreements, and Articles 7 and 8 describe those costs, what can be included and excluded from the work. And they're basically three buckets: those costs that are included, those costs that are included only with the owner's approval, and everything else which is excluded. Article 7 is the stuff that's included, and we did a fairly extensive redrafting of Article 7, although the general intent is still the same. We think we just made it much clearer so that owners, particularly those that are not sophisticated consumers of construction services, understand in that scenario what they are paying for. And some examples of clarification: we limited the cost not to exceed those prevalent in the location of the project. So you don't get to use California rates in Mississippi unless the owner agrees to it. People stationed at the project must also be performing work on the project, so you can't just put somebody on the job who's your safety guy and he does 20% of his work there and 80% on other job sites, but the project bears 100% of his cost. One thing that we excluded that used to be included are the bonuses and incentive payments to contractors' personnel. Those were a potential cost of the work, and we have made them a cost not to be reimbursed. Because of the cost of the work nature of A102 and 103, the owner has a vested interest in approving many of the costs in the cost of the work environment, and that's all opaque to you in an A101 environment. And so there is a list of things that the owner's written approval is required before the contractor can charge those to the works, things like prevailing wages, off-site workshops, wages of the supervisory and administrative personnel, and the list goes on and on. You can look at the document. The point is that each has the potential to be a profit center for the contractor as opposed to a market-based cost of the work. And so we created transparency for the owner to be able to understand what he's paying for and make an informed decision about that. We also strengthened the definition of a related party in Article 7.8.1. Why do we do that? Because when the cost of the work is used, the owner expects that the business is occurring at an arm's length, and they have a right to know if it's not. Go back to Forrest's discussion about acting in the interests of the owner. 782 obligates the contractor to disclose and obtain written approval from the owner if it intends to use a related party on the project. So, for example, if the contractor has an equity interest in its concrete sub, and it wants to use that on the project, then it just has to tell the owner, hey, I own this company, but we're going to bid it to 2 or 3 or whatever, or this is what it's going to cost you to use my contracting sub.
All right, and we've reviewed the Article 7 costs that are included, and so we get to Article 8. So what's not reimbursed? And it simply says anything that's not in Article 7 is not reimbursed. And you'd think that'd be straightforward enough, but we found that there are some things sometimes that the parties really need to specifically list as not included in the cost of work. And the one big change that Kevin already mentioned was bonuses, profit sharing, incentive, and that kind of stuff. And that really reflects the belief that the owner might not necessarily benefit from those kinds of payments on his project. So you get to the end of all of this cost stuff, and what do you do? The owner has a final payment process, which is fairly complex when you look at a flow diagram for it here. And this exists in 102 and 103 really because the owner has rights to audit. We modified that language because the language as written previously assumed there was an audit, and experience and from feedback from the industry says that's actually a fairly rare occurrence. So we altered the language to provide a sort of a quick off-ramp to final payment. And if you look at the diagram here, across the top, work gets complete, contractor submits his final payment. The owner says, no, I'm not going to do an audit. I trust this guy. We have that kind of relationship. The architect issues the certification and final payment is made. It's a fairly quick process. Coming off that diamond on the top row, if the owner elects to produce an audit, they produce an audit. The architect agrees or disagrees with the results of the audit, and that branches into 2 paths. The contractor has an opportunity to dispute the results of the audit or accept those results. If they accept the audit, you go to the line on the bottom and you zip right around to final payment. If he doesn't, then you go through into mediation and then final dispute resolution. One interesting thing is other conflicts might require an initial decision maker to issue a judgment. Not in this case, because the audit itself stands as the de facto initial decision.
So with the 2017 release of the AIA contract documents comes the removal of construction insurance requirements from the form themselves, and we put them into a separate exhibit document. This is kind of a big deal. These are the construction insurance requirements only. The insurance required of the architect, those still remain in the owner-architect's agreements. But you might ask, why did we create an exhibit? Well, There were a number of challenges with the way it was crafted in previous editions. First of all, there's complexity of insurance products and the nuance of individual projects. It's not simply a question of general liability and builder's risk insurance. Secondly, there was not sufficient flexibility in our documents to capture the range of coverages that a particular project might require. Third, the owners needed a tool to discuss with their insurance advisor what the appropriate coverages were for their particular project. Fourth, insurance is nowhere near as standardized a product as you might expect. And as a result, the industry is changing constantly while our documents only change every 10 years. And so it made it really hard to keep track of those changes and keep our documents current with where the industry was or wasn't going. We actually stuck our toe in the water on this issue with the 2014 Design Build Agreement, which uses an exhibit to record the required insurance. So that concept was birthed previously, and now we're deploying it across the portfolio. So given that set of problems, we figured, what can we do to fix it? The vision was we wanted to create a form that could be updated on a more frequent basis than every 10 years. That an owner could send to his insurance counsel or broker. It would cover the most commonly encountered bases, and it would also avoid the most commonly encountered exclusions. One of the things we learned was that a lot of insurance policies can exclude things that we would normally want included, EFIS is an example. And if we did this, we would facilitate the appropriate insurance coverage for a project, and we would reflect the best arrangement of insurance responsibility, what's best for the owner to buy, what's best for the contractor to buy. With that in mind, we dug into the detail. We identified the most common requirements. What does every project need? The common coverage exclusions that should be avoided, EFIS, as I mentioned before, fungi or bacterial exclusions to the CGL policy are a good example. And then the most common add-ons that people buy, things that aren't needed for every project, but enough that there ought to be a standard. Cyber insurance is a pretty good example of this one. And we compiled those into a single document that an owner can review with their broker. So what's in this exhibit now? The exhibit includes most of the A201 insurance provisions that you're used to finding in Article 11 of the General Conditions. By doing that, we put the coverage requirements and what it means to the parties together. We also broadened our previous approach to insurance. It brings together the most commonly required coverages, indicating who is to provide them, the required limits and where it is appropriate, the endorsement and exclusions that are typical in the industry, and those include owners' coverages like general liability, property, and others, contractors' coverages, including CGL, auto, employer liability, professional liability for delegated design required by the contract documents, workers' comp, and many others. There are instances, the property insurance, which we commonly refer to as builder's risk, for example, that can be provided by either the owner or the contractor, and the exhibit provides a vehicle to make clear who is obligated to do so. Also worth mentioning, the evolution specifically of CGL policies has resulted in the proliferation of endorsements for additional insureds, and the new exhibit facilitates making sure that everyone that is supposed to be insured by the required coverage is insured by that coverage. And last but not least, our old friends, the performance and payment bond requirements are spelled out here as well. So what's not in the exhibit? While we move most of the requirements that relate to project insurance into the exhibit, we left a handful of things in A201 in case the exhibit is not completed, including the obligation to purchase insurance required by the contract. That way, if someone forgets to complete the exhibit, there's a clue in the agreement that you ought to have someone responsible. The notice provisions, cancellations, or failure to renew the required coverages are still included in A201. The waiver of subrogation, which is the language that says if there is an insurance coverage, we won't fight about who is responsible for the events leading up to the claim and how an insurance loss is settled. That all stayed in the A201. And the question is, well, what am I supposed to do with this thing? And the answer is acknowledge to yourself that most of this is outside of your swing path as an architect. We're going to issue a guide document on how to use the insurance exhibit. Look for it in the coming months. But take this exhibit and hand it to your owner and advise them to review with their insurance counsel, or perhaps in a more streamlined way, you can ask the owner to arrange a meeting with the three of you and the contractor, if it exists, to discuss the project requirements, and then make sure it gets completed and attached to the contract.
All right, there's one more exhibit we need to touch on, and that's the contract document sustainable projects exhibit. There's a history of how we got here. In 07, we said, have a conversation with your owner. And then we developed a guide in 2011. It's document D503. In 2012, we took the 2007 version of the documents and added the sustainable project language to it and created dedicated SP variants, or sustainable project documents. Now, for reasons after we've had these in use for a while and good thought, we moved it to an exhibit, but just has some of the same reasons like the insurance. The contract issues that are appropriate for a sustainable project are all in one exhibit. It gets attached to each exhibit for the project. All the language is in one place. It's not likely to be treated differently in one party's agreement versus another. And it's E204 is the document name. All right, so there are some definitions in here. I won't spend a lot of time. Most of you should be familiar with these. But what is the objective of the sustainable efforts? How will we measure them? What is a sustainability plan and why do we want one? Who's going to be providing any sustainability certification? What documentation is needed? And who is the certifying authority? So this defines those terms. And then there's a scope of work in the exhibit for each. The architect's scope here first, they have to conduct a sustainability workshop, produce the sustainability plan, manage the sustainability during the design process to get those features incorporated in the design. Then they monitor and manage during the construction phase, and they are presumed to be the primary entity pulling this registration and submission activity together to get it to the certifying authority. So the contractor and owner have obligations under this too. The contractor performs those sustainable measures that are identified in the agreement form. If they want to make a substitution, they have to tell us how it affects the sustainable objectives for the project. They have to complete their portion of the documentation. They have to send this exhibit downstream to their subcontractors so that they're doing their part under the sustainability plan. And their scope continues through substantial completion all the way to the certification of the project by the authority. And the owner has a scope too. They approve the sustainability plan. They may have some obligations to provide information or services and require that their other parties to other agreements are acting in accordance with the sustainability plan. They provide the services of the commissioning agent. And the final point on this is that sustainability plan is a contract document, and it should be coordinated with all of your other documents and treated in much the same way as you would specifications to the project.
So we've gotten to the end. I apologize. We ran a little long. Forrest and I could probably talk about this for a good half a day at least. We appreciate your attendance and listening to us. So hopefully you picked up what we talked about at the beginning, that a little bit of understanding about how these contract documents are drafted, the fact that they're not simply some attorney sitting in a office someplace putting these together, but that industry experts participate and really seek to provide a fair and balanced set of agreements. In particular, those owner-contractor agreements are trying to find a way to balance information, time, cost, and risk. And you got to choose the right one for the right situation. Not one doesn't fit all. The 2017 revisions for these documents, as well as across the board, are not huge, earth-shaking, but they are substantive, and the documents, the new ones, improve upon what we had before. Most of the changes in the documents we discussed today revolve around following the money. That these exhibits that we have give you a great deal of flexibility to suit your project needs to the contract documents that we provide. And then lastly, there's a ton of resource material available to you. Asti?
I'd like to thank both Kevin and Forrest. There was such a tremendous amount of work that went into creating this presentation, so thank you both for that. I want to let all of our attendees know that your credit will be reported to the AIA if applicable, and if you entered your AIA member number when you registered. You'll also be receiving the PowerPoint and the recording from today's webinar at the conclusion. We also place all the recordings of these webinars on our Learn page. You see the link there. Also check out AIA contract documents on AIAU. And if you have any questions about our content, please contact docinfo@aia.org. We're happy to assist you there. There is one question that I think we can answer real quick before we conclude today's webinar. There was a question that was, when is it applicable to use document A104 and A105? Any response?
I'll attempt that. 104 and 105 basically take some of the same language that you see in these larger ones and decide that you might be able to get your project done without some of the contract language that's in there. And really, I think you have to assess what is excluded in the smaller versions and make a determination as to whether you think the likelihood of project risk is high enough to warrant the additional language. It really has to do, you might find them more appropriate on smaller projects or projects where the parties have a greater familiarity and past working relationship with each other.
Okay, and with that, I'm going to conclude today's webinar. Again, thank you to our presenters and thank you to all the attendees. Please look forward to receiving the email with follow-up materials. We wish you a great afternoon.